Hello, everybody. Let's get this party started. Let's talk again about the case of State of Florida versus Donna Adelson. And in this video, I'm going to be talking about two motions filed by the defense. I think it was great for Donna. It was a smart choice by Donna to hire a good lawyer, Alex Morris, who also has a lot of experience with appellate work. A good appellate lawyer, and I've done more than 100 appeals as well myself. A good appellate lawyer is really good at spotting issues and arguments that can be made, that should be made in a case. And so I can tell you that there are several motions that have been filed by the defense, and all of them, or most of them, seem to have good grounds, right? So these are arguments that probably should be made. Now, whether they're going to prevail or not, that's sort of what we're going to talk about. I'm going to give you my opinion on that issue. But they at least identified issues to be raised with the court and issues that, at least merit some discussion. And we're going to talk today about two of the motions that were filed because they're both related in a sense. So the one motion that I was planning to do exclusively on this video is called Defendant Donna Adelson's motion to dismiss indictment for pre-indictment delay or alternatively to exclude evidence. Now, I'm only going to talk about the motion to dismiss part because I haven't even read the second half of this motion that talks about excluding the evidence. And then I'm also going to talk about a related motion, and I'll explain to you why it is related. But it is Defendant Donna Adelson's motion to preclude evidence of Donna Adelson's travel as consciousness of guilt. So those are the two motions I'm going to talk about. And let's just, in general, first of all, talk about the principles at issue right here. All right. So on the first issue, the first motion, the motion to dismiss the indictment for pre-indictment delay. There is case law that talks about that being a possibility, right? That a case may be dismissed because of some misconduct by the state that caused prejudice to the defense. And what is the general rule? Let me see. I'm going to read it to you guys from a case called United States versus Stokes out of the First Circuit Court of Appeals of the United States Court of Appeals. And this is a 1997 opinion, and it talks about the issue of pre-indictment delay. And here's one paragraph that kind of sums it up what is required for you to be able to rely on that kind of argument. So it says, Stokes' renewed claim of unconstitutional pre-indictment delay lacks substance. A criminal defendant who asserts such a claim bears a heavy burden of showing not only the pre-indictment delay caused him actual substantial prejudice, but also that the prosecution orchestrated the delay to gain a tactical advantage over him. Right? So what are they talking about here? Let's put it in common sense words. So, for example, right, let's say that the state of Florida believed that Donna Adelson was involved in this murder and that they were going to argue that she dropped off the money at Charles Adelson's home. Let's say that they knew this right away and that they, on purpose, orchestrated the delay, did not charge her for 10 years or 9 years, whatever long it took here, not because they were trying to develop evidence and they didn't feel like they have enough or some other good reason, but because they wanted to preclude her from obtaining exculpatory evidence. They figured, oh, shoot, we can argue that she dropped off the money, but if we wait a few years, she'll never be able to get those records, and now it's going to be an easy conviction. So let's delay. Let's not file now. Let's delay so that later on, when we finally get a charge her, she's not going to be able to defend herself. If something like that were to happen, and you can prove that, and then you can show that there was actual prejudice, and now, yeah, you can argue those toll records or whatever, then you may have an argument, right? But even without reading the motion, let's just backtrack for a second. I mean, because the initial reaction, the initial gut reaction that I have when I read this is like, I mean, do you have the audacity to really argue this? Let's consider all of the facts that we know, right? Based on Charles Adelson's own testimony, the Adelsons knew that they had a connection to this murder, even if they were not involved, even if they were totally innocent. They knew that they had a direct connection to this murder through some people that supposedly did it for them and then wanted to collect money from them. They knew this from that night while Dan Markel was still alive. Charlie knew that night, supposedly. And then a few days later, a few weeks later maybe, his mom learned about it when she was asked to write several checks for Catherine McBanua. And then she confronts her son, why are you asking me to write all these checks? And he tells her the truth. So back in 2014, the Adelsons already knew this. The Adelsons already knew that they could be implicated in this murder. Now, of course, the defense doesn't have any burden to do anything once they're charged. But here, let's just take a look at the hypocrisy of this motion, right? The defendant in this case, Donna Adelson, knew that there was all this evidence that would point towards her family's involvement and her involvement in the case. They could have gone to law enforcement. They could have gone to a lawyer and tried to develop any and all possible exculpatory evidence back then, knowing that someday the state might find some evidence to charge them, because you know what? Those people that are extorting us may someday decide to turn us in. If they get caught for something else, whatever, they're going to try to make a deal and say that they have evidence about who murdered Dan Markel and that it was all ordered by the Adelsons and blah, 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 right? So they had a humongous interest in developing that evidence, that supposedly exculpatory evidence themselves, way back when. And then the prosecutors, by the way, the other side is arguing when this happens, right, that the evidence of the probable cause affidavit is leaked. And so what do the Adelsons say? That this is, and the attorneys for Catherine McBanua and so on and so forth, this is horrible, this was leaked to the media, they're just going to the media, they're trying to crucify these people and all this stuff, and their own prosecutor says that there's not enough evidence. The Adelsons hire attorneys. They announce that they have nothing to do with this murder. They don't say that they were extorted. They don't say that they know who the killers were. Nothing. They say that we're 100% innocent. We have nothing to do with this. We're glad that the people that killed the Markels were caught, or the Markel were caught, but we have nothing to do with this. And they're lawyered up, right? And so, again, even if they were not smart enough to hire lawyers and develop evidence back in 2014, to help prosecutors too, to help prosecutors prove the case against the real killers and extorters, right? In 2016, they could have done that. So there's all this hypocrisy already from that perspective, right? From the fact that the state wasn't trying to hide anything. They already did a probable cause affidavit, giving warning to, like they said, giving warning to Donna, hey, you are a target of this, right? And if we see the motion, the argument, for example, concentrates on the fact that the defense is not going to be able to prove, for example, the whole issue about the money drop and the fact that the toll booths or the SunPass records would show that she wasn't at her son's house that night to drop off money, wet money, to Charles Adelson. And so that's the, like, I guess the main issue that they argue why they're prejudiced, right? Because they cannot disprove this suggestion that she was there. But when did the state know about that, right? So the state knew about that much, 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 much later, right? They only heard for the first time somewhat during the proffers of Catherine McBanua. Maybe you can half interpret her to say that, because eventually, I mean, that was very painful to listen proffer. The first one and the second one were both difficult to listen. Catherine McManua was all over the place. She never was clearly stating anything. And so maybe at some moment she suggested that the mom stopped by the house. And then eventually that was actually used at the trial, right? Against Charles Adelson. But that's when they learned about it. This is long after Charlie was arrested. This was after Catherine McManua was convicted. So by that time, when they learned about the supposed money drop, the records probably wouldn't have been available, right? So it's not like they orchestrated anything. They were, in fact, charging the people that they thought had a direct connection and would bring them the Adelsons in a platter right away. They were not trying to delay. They were trying to do it right away. They were cautious. That's a different story. They were cautious, especially because of the fact that the Adelsons were all lawyered up. They were claiming full innocence and all this stuff. And obviously, this is a difficult case. There was well-planned murder with an in-between person who would shield the killers from the people ordering the hit, and it was hard to prove. And the bump was successful in a sense, but again, it wasn't clear-cut, right? I mean, Donna does say it's about the two of us, but then again, about the two of us could be about the fact that she's helping after the fact, paying for the extorters or paying for the murder without having been involved before. So it was never a super obvious, clear case where they should have immediately charged. It was something where many people thought, like myself, maybe, I don't know, maybe I was the only one, I don't know, but I mean, I have been speaking about the fact that probably the Adelsons should have been charged long ago. And before any Adelson was charged, I suggested that they should be charged and that at the minimum, it should be at least one of them. And the state actually did that. But this is not a situation where the state was orchestrating a delay to gain an advantage, right? It's not a situation where they had full cooperation of Catherine McManua way back when, back in 2016-17, knew about this suggestion that Donna Adelson stopped by the house to drop off the money, but held on to that information for another 9 years so that Donna Adelson could disprove it, right? So, okay, there may be some actual prejudice from the fact that there was a delay. And that part they may be able to establish. Don't know. But they're never going to be able to establish that the prosecution orchestrated this delay to gain a tactical advantage over Donna Adelson. That would be a pretty absurd argument, in my opinion. So that will never fly. Going to read a little bit this motion and actually give a little more detailed discussion, but I'm just giving you my preliminary thoughts about the two motions. So that's my general thoughts about the motion to dismiss for pre-indictment delay. Again, I personally think that the defense is kind of stuck with the story about the extortion and all that, and they should have done although they don't have a burden to defend themselves and the state has the burden of proving guilt, they should, if they were victims of extortion and they knew that they were potentially going to be mistakenly charged for a murder that they really didn't want to happen, they should have, if they decided not to cooperate with the cops and get the cops to then investigate and do all their searches and corroborate their own story, which they would have done if they gave a story and said what they did and didn't do. If they had cooperated from the beginning, the state would have gone there. Maybe they would have asked for those records that they're complaining about that nobody got. So those are my initial thoughts before I discuss with you the actual motion. Now, the other motion is the Donna Adelson's motion to preclude evidence of Donna Adelson's travel as consciousness of guilt. And so let's talk about it in general. What is that about? Okay? When people flee from the police, it can sometimes mean that they have guilty conscience about something that they have just done, right? We actually have a case that I published a video that Ladybug and I prepared, and we published a few days ago. They got almost 0 views, whatever. Got very few views, but it was a good video. And it was a good example of a situation where evidence of flight probably wouldn't have come in at the trial. So what happened was there was a woman who may have been on drugs or something, but she was acting kind of bizarre. She says she's walking on the street and that some guy stops the car and tries to kidnap her. And then she describes to the cop the person. She says it was a white guy, and then she says he was driving a white SUV. The white SUV had a bike rack on the top or something like that, or in the back. So she gives a description of the vehicle, and she gives a description of the guy. Says it's a white guy, and gives a little more description. So police are driving around, and then they run into a white SUV with a bike rack, something similar to what this woman described in the neighborhood. And they turn the sirens on, and the guy just starts to fly away, at full speed, puts other people in danger. Eventually, I don't know if he crashed or stopped and ran, tried to run on foot. The cops eventually catch him. He gets beat up a little bit, gets tasered, and gets injured as he falls down, I guess. I don't think that he got beat up. I think he just got tasered, and they had a pretty bad injury when he fell on the ground. And so it turned out that in that case, the guy who was running away from the cops was black. Now, is it possible that the witness gave the wrong color of the skin? Yeah, it's possible. But the more likely scenario is this, right? We find out that this guy had a suspended driver's license and had drugs in the car. Okay, and here are the cops turning on the sirens. So this guy had excellent reason. Well, there's never good reason to run away from the cops, but he had a different reason to do the irrational thing of running away from the cops. It was the fact that he had a suspended license and that he had drugs in the car. Speeds off. So, Miranda, that's a good question. I think it's a video that's still published on the channel a few days ago. I'll see if I can get a link and I'll put it for you guys. Let me see if it's still published. Anyway, so the guy flees, and the case was resolved, and the guy didn't obviously get charged with this attempted kidnapping. They were reducing just to, I think, the fleeing portion, fleeing law enforcement, putting other people in danger. The guy's girlfriend came forward and testified, and obviously this is mistaken identity. It wasn't him. He's a good guy. He was just driving my car. Blah blah blah. So that's a situation where the evidence of flight might not come in because the prosecutions may have a weak case, right? They say, oh, well, this guy was driving a white SUV, looked the same, and then when we turned the sirens on, he took off. We want to show to the jury that this is evidence that he was the guy who attempted to kidnap this woman. But there's also this evidence that nobody can contradict, that the woman just minutes before, described without any hesitation the man as being white, and the person who was driving the white SUV that got stopped was clearly black. So in that case, introducing the evidence of flight, knowing that the guy had other reasons for the flight, to try to show that he was the attempted kidnapper would probably be very unfair. And in that case, that evidence wouldn't come in. You cannot tie it directly to what happened to that woman. And there were other things in that case that would tie it. I mean, the guy was in the area. He was driving a very similar car and so on and so forth. But he was clearly different color of his skin. And so it seems to be just a bad coincidence. And now the probative value of the whole thing of him fleeing the cops versus the prejudice that it would cause to the jury. Now the jury hears this guy is a bad guy. He's doing some other bad stuff. So maybe he was a kidnapper. Maybe the woman was mistaken. It's just very highly prejudicial. So judges will try to give defendants a fair trial. And in that case, the right decision probably would have been we're not going to allow the state to introduce the evidence of this flight. Okay? Now let's go back to Donna. they make a good argument, and an argument that they should make. They have to try to do technical challenges to all the good evidence that comes in the case. And by the way, one of the reasons why I thought that the two motions were tied together is because one of the arguments in the motion to dismiss is that the state of Florida has had the same evidence for the last 10 years. And that is incorrect. There are two, from what I know, from what we all know, there are at least two huge pieces of evidence that are brand new. That would be Catherine McManua's testimony and proffer. They didn't have that back in 2016, 2017, 2018, 2019, so on and so forth. Some argue that it is because there is a connection between the Adelsons and the lawyers representing Catherine McManua. I mean, I think that this motion could open that Pandora box again, but who knows? But bottom line is that there is all that evidence about Catherine McManua that came in much later. And then on top of that, there's also this evidence that we're going to talk about right now, the whole evidence of Donna Adelson trying to escape the country, allegedly, right? That's the argument from the prosecution would be that she's trying to flee and that proves consciousness of guilt for the murder. So the defense is arguing, hey, wait a second. They discussed this trip with friends. This was one of many, many, many trips to countries abroad. Many of those countries have no extradition treaties. Donna Adelson knew for a long time that she was a suspect and never flew the country. There's nothing to show that this departure to go to Vietnam is evidence of any kind of guilt on her consciousness that she killed Dan Markel, that she participated in the murder. And it would be highly prejudicial to introduce this evidence to try to imply that this is why she went to Vietnam when we're like so far removed from when the murder happened and her supposed involvement in the murder, blah, blah, blah. But again, this is like a one-sided presentation. I understand the defense is doing the defense work. I mean, they're not going to make the argument for the state. But I personally think that you always do that. You actually, when you do a motion, you evaluate both sides and you evaluate the evidence fairly. You actually gain credibility with the judge if you say, here are all of the facts. And then, well, even considering all of the facts, you still shouldn't allow this evidence to come in. But they don't do that. They actually they misstate the facts and completely fail to analyze all of the evidence that the state obtained by getting her calendar. That calendar is a huge piece of evidence, and that calendar demonstrates many things, including the fact that she was hiding the trip from people, that she was using her attorney to communicate with Charles Adelson private, so they wouldn't be heard on by law enforcement who are monitoring the phone calls. The fact that she was telling friends, according to her own entries on her cell phone that they confiscated, suggesting that they were going on a vacation, suggesting that they had a family emergency. They have a note in the calendar to tell somebody about where they are after they're gone. So there's all this evidence that there's the searches on the phone or on the computer to find out whether Vietnam is still a non-extradition treaty country. All of these things. There's the interview of Georgia Cappleman immediately after the trial. We know that they have been watching all of that, so they have the interview where Georgia Cappleman is the first question asked. It wasn't by me, it was by somebody else. Who's next, right? So you have all those things that connect the travel to Vietnam and the whole emergency of how they decided in just a few days after the conviction happened and the departure, right? Just a few days from November 6 to November 13. That's like a super rush, 7 days in 1 week. They go from being in Miami to trying to leave to the country to go to Vietnam. So the analysis here is missing all those facts. And so those are my general thoughts. So my general thought is that this is enough evidence of consciousness of guilt because of the factors that I just told you. So they can try to argue to the jury, hey, listen, she had other reasons, maybe she was afraid of getting it for trial, whatever. They can argue whatever they want to try to argue, but I think that it is enough evidence of consciousness of guilt that it should come in. We'll see how Judge Everett rules on it, but now I'm just going to go do a little more in-depth analysis of the two motions. So this part from now on will maybe a little more boring for the people that don't like all this legal stuff. I'm actually not gonna. I'm just gonna read portions of this and then give you my thoughts as I go along. But to try to save your time, what I did is I gave you the gist of my thoughts about the two motions up front. So if you're coming in later, not live, and you just want to watch that portion, now it's done. So now let's go a little more in depth into those two motions. All right, here's Donna Adelson's motion to dismiss indictment for pre-indictment delay or alternative to exclude evidence. So the preliminary statement says the case presents an egregious example of pre-indictment delay. The state began its investigation with Mrs. Adelson among its prime subjects just hours after Professor Markel's murder in July 2014. By 2016, the state had focused its efforts through witness interviews, document subpoenas, blah, 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 to charge her alongside her alleged co-conspirators. In fact, the state's evidence against Mrs. Adelson has remained largely unchanged since then. And that's one part that I disagree with. So they say that since 2016, the evidence is largely unchanged. I think that there's two big significant pieces of evidence that came in against Donna. I think that Catherine McBanua would be one. The other one would be all the stuff that was collected after her arrest. So there you go. Oh, actually, no. There's three. Let's not discount the whole admission by Charles Adelson that that they paid for the hit, right? That he paid for it with cash, supposedly from his safe. Maybe he was trying to protect his mom and not revealing that she brought it over. That's a possibility, right? So now they want his admission to somehow be a fact, But that was a convenience admission, I think, a part of their strategy, and maybe one that also involved saving Dan Rashbaum's other client, which clearly Donna was acting like a co-client of Dan Rashbaum throughout the prosecution of Charles Adelson. So I disagree that it remains largely unchanged since then. I think that the trial did present evidence against Donna because after never disclosing for many years this supposed crime that happened against them, they did admit at the trial of Charles Adelson that the payments were made by them. Charlie admitted that he gave money to Catherine McBanua, and then he also admitted that his mom wrote those checks and that he told her about the whole extortion. So he kind of, she's a lot more embroiled in the murder than just from us interpreting the wire calls. Now you have the sworn testimony of her son that didn't work, but their hope was that they were going to, his hope was that the jury would find him not guilty because he was a victim too, but that didn't fly. But I think that the state can say that that's additional evidence, that it's not just Catherine McBanua, it's not just the stuff that they found after they arrested her, it's not all the stuff that they got on the jail calls too. By the way, the jail calls are evidence too, that conversation that happened after she thought that she was going to hang up, that she had hung up the phone, and she's talking about fleeing to Vietnam and all that. So, no, there's a lot more evidence against Donna than whatever they had in 2016. And we may not know all they had in 2016, but there is a lot more since then. So that's an unfair statement. Yet the state made the intentional, so I'm going to go back to reading. Yet the state made the intentional strategic decision not to charge Mrs. Adelson for almost 80 years, choosing instead to pursue charges against 4 of her purported co-conspirators first. I don't think that there's anything wrong with that, right? With going up, first charging the people against whom you have the most and best evidence, and then hoping that they will flip and give you more evidence against the others. A lot of people criticize it as being wimpy, as being too scared, as saying, a lot of people, maybe including me, said that there was enough evidence already from what they had in 2016 after the bump to charge Donna and Charlie. But I understand the state's strategy of being more conservative. So being conservative and trying to develop more evidence against the defendant where the case is maybe a little bit weaker, that doesn't sound like a strategic decision that was intended to deprive Donna Adelson of a fair trial. So when the state finally decided, I'm going to go back to reading. So when the state finally decided to seek an indictment against Mrs. Adelson, more than 9 years had passed since the murder. By that point, exculpatory documents critical to her defense that the state never saw fit to obtain, including cell phone records that to refute the state's call pattern claims and SunPass records to refute the state's unsubstantiated and inaccurate suggestion of a money drop, were lost to foreseeable document retention policies, causing substantial prejudice to her defense. Accordingly, the indictment should be dismissed as a violation of Mrs. Adelson's due process rights. But if the court is unwilling to do so, at a minimum, it should preclude the state from introducing evidence that Mrs. Adelson can no longer defend against because of the state's charging delay. So, again, the rule of law on this issue is not just that there was a delay and now the case should be dismissed, because it's kind of like rewarding the better criminals, right? So if you make it harder for the state to charge you, and now you can, because the state took so long, you're going to say, now I'm prejudiced because I cannot defend myself. That would seem to be absurd. That rule exists to protect defendants from misconduct by the prosecutors that are hiding the fact that they're going to charge somebody, okay? Lulling the defense into non-action that once they later decide to finally bring the charges, once they reveal the fact that they're going to go after you, now you can't defend yourself anymore. It's not just about delay. It's about a strategy from the state. And that's going to be something that is pretty much impossible to prove in this case. Because, like I said, from the very beginning, the state was quite forthcoming in asserting its position that the Adelsons were involved. They didn't have the details. They didn't have Catherine McBanua mentioning the potential of a money drop. But they certainly let everybody know that their targets are the Adelsons. Not all of them, of course. Robert had nothing to do with this, but they put on their charts from day one, from trial one. Okay, on the one side, like the killers, and then you have the 4 Adelsons, right? Wendy, Donna, Harvey, and Charlie. They're always part of the state's theory. So that seems to me like an argument that's not going to hold any water. Then they give the background. I don't think I need to read this background portion. They're saying that obviously the Donna Adelson was a target from early on, that they also subpoenaed and combed through Mrs. Adelson's personal and business records going back to January 2013. I wonder if they got her calendars for 2013, 2014. That would have been nice. And of course, in 2016, they should go back and look at those records. I don't know, maybe they don't know they have a gem hidden somewhere that nobody reviewed. And of course, in 2016, they conducted the bump and the wiretap recordings and all that. So it says, so by May 2016, the state had in hand virtually all of the evidence that it is likely to present when Mrs. Adelson's trial convenes next month, almost a decade later. Again, I disagree. There's a lot more evidence now. But the state did not charge her in 2016. Instead, it made the strategic decision to pursue charges against the shooters and Miss McBenoit first, hoping that they would plead guilty and reveal that what the state believes was Mrs. Adelson's involvement. But that did not happen. And so Mrs. Adelson remained uncharged through 2 trials, and one in 2019 and another in 2022. The state also failed to charge Mrs. Adelson when it charged Charles Adelson in 2022. Once again, the state chose to delay. It wasn't until after Charles' conviction, with no new evidence to bolster its case, that the state brought charges against Mrs. Adelson on November 15, 2023, 9.5 years after Professor Markel's death. I think the whole point about the fact that she wasn't charged with Charlie at the same time seems to be irrelevant to me in this argument, because I think that what they're going to try to say is that the delay and the document retention policies would probably be like 5 years, not 8 versus 9 years or 7 versus 9 years. So it doesn't really make a difference. I think that they probably would have made the same argument if she was charged when Charlie was charged. Anyway, let's see their discussion. So the state's 9-year delay in charging Mrs. Adelson warrants dismissal under the Due Process Clause. I'm just reading through to see what portions I should read to you guys. Even indictments brought within the limitations period are subject to dismissal where the delay departs from fundamental notions of fair play. Citing United States versus Foxman. When the pre-indictment delay, 1, causes substantial prejudice to a defendant's right to fair trial, 2, and 2, was the product of bad faith on the part of the state, dismissal is required. And it cites to the Jackson v. State case. Now, even the Jackson v. State case was one where that argument was rejected by the court. In Jackson v. State, I think I did download it. Here we go, Jackson v. State. The Florida Supreme Court didn't even, and even in that case, didn't hold that a case should have been dismissed. Let's see what they said. One second. So that's a murder case too. All right. So I'm going to read from the opinion. 5, motion to dismiss charges. So the Florida Supreme Court is writing about this issue. Okay. Jackson, let me go back to the beginning for a second. So this is page 7. Okay. So this is a case where the defendant was convicted out of Duval County of first-degree murder and was sentenced to death. The name of the defendant is Kim Jackson. So let's go back to page 7. So on page 7, the court writes, oh, let me shut off sorry about that. I'm going to shut off the email so you guys don't hear those sounds. Sorry. All right, let me read that. Just 1 second, guys. Okay, motion to dismiss charges. Jackson argues that the circuit court, the trial level judge, erred in denying his claim that the trial counsel was deficient for failing to file a motion to dismiss the charges on the basis of prosecutorial delay. In denying this claim, the circuit court ruled that a motion to dismiss for pretrial delay would have been meritless, We agreed that Jackson is not entitled to relief. In so deciding, we reconsider our case law on the due process standard for pre-indictment delay. In Rogers v. State, we adopted without significant discussion a balancing test to determine if pre-indictment delay violated due process. That test traced back to a Fifth Circuit decision in United States v. Townley back in 1982. We describe the Townley test as follows. So this is the test that they are backing out of and changing. So the Florida Supreme Court, before this opinion in the Jackson case, were following this standard. I'm going to read it to you. When a defendant asserts a due process violation based on pre-indictment delay, he bears the initial burden of showing actual prejudice. If the defendant meets this initial burden, the court then must balance the demonstrable reasons for delay against the gravity of the particular prejudice on a case-by-case basis. The outcome turns on whether the delay violates the fundamental conception of justice, decency, and fair play embodied in the Bill of Rights and the 14th Amendment. So that was the former test. Then it says, since we decided Rogers, the Fifth Circuit has receded from Townley balancing test. In doing so, the Fifth Circuit cogently explained the flaws in the Townley balancing test reasoning. So now here's the Fifth Circuit Court of Appeals, federal court, explaining why they no longer do this balancing test. Here's what they say. The Townley test purports to weigh or balance the extent or degree of the actual prejudice against the extent to which the government's good faith reasons for the delay deviate from what the court believes to be appropriate. However, what this test seeks to do is to compare the incomparable. The items to be placed on either side of the balance, imprecise in themselves, are wholly different from each other and have no possible common denominator that would allow determination of which weighs the most. Not only is there no scale or conversion table to tell us whether 80% of minimally adequate prosecutorial and investigative staffing is outweighed by a low medium amount of actual prejudice, there are no recognized general standards or principles to aid us in making that determination, and virtually no body of precedent or historic practice to look for guidance. Inevitably, then, a length of chancellor's foot sort of resolution will ensue, and judges will necessarily define due process in each such weighing by their own personal and private notions of fairness, contrary to the admonition of the United States Supreme Court in the United States versus Lavasco. Apart from the above difficulty grounding, so now is the Florida Supreme Court talking again. So apart from the, I think it is, let me see. Okay, I'm just going to skip this part. So it says, contrary to these principles, the Townley test would find a due process violation where the government acted in good faith and did not deliberately seek to prejudice the party ultimately accused. Finally, the serious separation of powers concerns are implicated. Here, for example, the panel concluded that the reasons for the delay, such as lack of manpower and low priority which this investigation was assigned, were insufficient to outweigh the actual prejudice to couch and fry. Finding these reasons insufficient is in substance determining that greater manpower should generally have been allocated to investigation and prosecution and that jurisdiction, and that a higher priority should have been assigned to this particular investigation. So those are decisions by a different body, not by the courts. And so they're backing off of this test. So in essence, they switched to a new test. And I'll get to that part. So Jackson has not made that showing. He does not claim to have relied on Rogers. Let me go to the bottom line of this case. Based on the analysis, excuse me. So the Florida Supreme Court says, so based on the analysis above, which I only read to you part of it, we received from Rogers balancing test, that one that adopted the Fifth Circuit's balancing test. We now align ourselves with the majority of federal courts and hold that a due process claim for pre-indictment delay requires a showing of substantial prejudice to the defendant and bad faith on the part of the state. And like I said, I read to you guys United States versus Stokes, which is the first case they cite. And in the United States versus Stokes case, they explain it even better. They say that the defendant has a heavy burden of showing not only the pre-indictment delay caused him actual substantial prejudice, but also that the prosecution orchestrated the delay to gain a tactical advantage over him. So bad faith. Excuse me. Need to get some water. I'll be back. Sorry about that. What I do like about this motion, however, is that it puts the government on the spot a little bit, and that hopefully then we'll get to hear an explanation from the state about its decision to not charge Donna Adelson, maybe Harvey Adelson, and Wendy as well, for so long. So in a sense, I kind of like that this motion was filed, and I'm looking forward to reviewing the response from the state, but I just don't see the defense being able to show the bad faith component of the test. They may be able to show some prejudice, although I already explained to you why that seems to be a little bit hypocritical, because they knew about their supposed involvement from a long time ago. So even assuming that Donna, for example, was not involved, and that she helped her son pay extorters. That's what she believed. She knew about her, that she could be wrongfully, in a sense, charged for this murder way back when. They lawyered up. They never cooperated. I mean, it's really hypocritical in many respects. But it is what it is. So they talk about the prejudice, right? So the actual prejudice would be the whole issue about the transponders, the sun pass, maybe phone records from before to show that they were always on the phone with each other, that it wasn't just around the time of the murder. Because obviously, I think that Katie's defense tried to do the same, even Rashbaum tried to do the same at Charlie's trial. Talk about the fact that, well, yeah, they show all these phone calls happening around the time of the murder, but these were all people that knew each other: boyfriend, girlfriend, mother, son, brother, sister. They always were talking to each other. So you make it look like this was something proving that they were involved in the hit. Yet, if you go back several months, the whole past year, you're going to find many days where it had no connection to any murder, where they're talking the night before, the next morning, this stuff. So that's sort of the argument that has to do with the phone calls and all. And of course, this whole issue about getting the SunPass records, the transponders, to try to show that Donna wasn't dropping any money and all that stuff. So I don't think this motion is going to fly, primarily because there's no way that they're going to prove any bad faith. But I am looking forward to reading the response from the state so that we can hear an explanation for the delay, which I'm assuming is going to be very similar to what I just said, is the fact that they felt that they had a good amount of evidence, but not enough to quell any concerns. Maybe there was dispute between them about whether there was enough. Maybe some thought that it was, others thought that it wasn't, and the boss is the boss. The boss decided it wasn't enough. But they didn't hide anything from the Adelsons. The Adelsons knew from very early on that they were targets. So anyway, and then the other explanation is, of course, we didn't know about the supposed money drop until we talked to Mike Manua, and by then it was too late to get additional records. We did a very thorough investigation. In fact, Dan Roshbaum had said, and so did, I think, Charlie, I guess, or I don't know who else, but they admitted that the investigation was amazing and that they did a terrific job in finding the killers. So, all right. Maybe I should have a chat with you guys. Enough of these motions and I'm chatting with you guys instead. Huh? You guys want that? Do you think I said enough about these motions and we'll just move on? And just have a little chat, a little Q&A? Who wants that? If Skitter Girl says, let's do it, then I'm going to do it. Or New York Patriot Lady. Hello. One of you guys, if you say, let's just do a Q&A and forget these motions, let's do that. All right, let's stop. That's it. Enough emotions. Goodbye. There will be a hearing and a judge deciding them. So, all right, guys. I kind of saw that you guys are having some good conversation, but I didn't get to read anything. So I'm not going to scroll back. Let's go to the present. You have any comments or questions or thoughts? Uh-oh. Yeah. Which photo? It's cooking. Well, it hasn't been placed anywhere yet. I can just remove it. I haven't put it on the wall yet, so it's gonna be on the floor now. Evenly on the floor. Sorry about that. Hey, Helen, I see you have a new photo for yourself. That's cool. Hello, Dr. Cancella. Okay, questions, guys. Anybody has any question or request? Do I need to move anything else in the furniture here? All right, you guys are in charge. If I see a question mark, I'll answer. Otherwise, I'll just be quiet. You didn't have to worry. Don't have to worry about it, Kathy Frank. That's cool. What is seating capacity between the both courtrooms, James? Good question. Okay, I did a video about it last night, and then I made it private for a second because I kind of messed up. I showed 3B first, which is the last place I had a jury trial. It's a very small courtroom. I did a trial there. My last felony trial was there, courtroom 3B. It's very small. You can see the video that I did last night. It actually shows it. It doesn't show the gallery, but the gallery has basically maybe three wooden benches on one side, three wooden benches on the other. It maybe fits 30 people, maybe 35. And given the number of people who were attending last time who were from the media, I would say at least 20 last time. So it basically would mean that between the media and the family of Dan Markel, there would be almost no space for anybody else. Very few people from the regular audience, I guess, would be able to sit there. Good question. All right, what's the next question? Oh, James, okay. What time is it? Hey, Paul. That's a real question. What time is it? I don't know. It's 4 p.m. Didn't Donna's note say something about investing in real estate in Vietnam or something? Yes, it did. Her calendar throughout the year talks about the fact that they were buying some Vietnam villa. They were investing in it. They had it furnished. They spent about $135,000 on it. Judy's in the house. She says, oh, that's not a question. I'm watching the bad YouTube ads first to support the channel. Don't do that, Judy. Only watch them if you're interested in the commercial, because then the commercials are effective. And then more people will advertise on YouTube. If people just watch it to support the channel and they don't give a damn about what they're watching, I don't know that you're supporting anybody. That's a lawyer talk for Judy. Can you make a legal counter argument to that, Judy? All right, I'm not. Okay, so question marks. I just hear, when does her trial start, please? So it starts. Jury selection starts in the middle of September, so it will start towards the end of September. And the audio quality is dog crap. Sorry. This is not a podcast. I'm not a podcaster. I guess I am a YouTuber, but I'm a lawyer primarily, and I haven't invested in a studio. If someday I decide to invest in a studio, you know, because it will sound much better. But right now I don't have a studio, so it is what it is. Here's a question. Oh, there's another question one first. Cam. The police officer who passed off Donna's travel bag to Harvey when she got arrested, did he get into trouble for not keeping potential evidence? Oh, I don't know. I don't know if he got in trouble or what, or whether they still confiscated it. I think they would need to get a subpoena for that. So anyway, Sandra, can the facts that Rashbaum attended Catherine McBanua's trial be used in the state's response about the delay? Can the facts that Rashbaum attended Catherine McBanua's trial? I don't think that you need to go. I mean, no. I mean, the Adelsons already knew about all of the probable cause affidavit long ago. So the fact that they knew stuff, that's not really. I mean, I kind of mentioned that myself, right? So it's a little bit hypocritical in a sense, but obviously the state has the burden of proving the case. So the main issue is going to be, I think, there's no bad faith. So we don't even need to go to the question, okay, sure, maybe don't have some of those records anymore. Well, first of all, we didn't even know about the fact that we might need those before. Number one. Number two, There was no bad faith in the delay. We were just trying to make sure we had enough evidence. And when more came in, we decided that finally we have enough. That's it. Hi, Judy. Which defense motions do you think will be granted, if any? I'm concerned about the move to 3B, because maybe the judge has the power to do it. He can do it if he wants to. I don't want it to happen. I think it's going to be bad to do that, but he was the judge presiding over Charles Adelson's trial. He got to see whatever was happening in the gallery. He did a couple of times not like, I guess, what's going on. I think it was clear from his face, from his reaction or comments in the breaks. So that's something that he might have an interest in doing. So that's a possibility. Let's see, I have all the motions printed, and I have not read them all yet. So I can't talk about stuff I haven't read, but the courtroom 3B might, or maybe he'll pick another one that is in between, not as big, not as small. The consciousness of guilt, I don't think that's going to be granted. The motion to dismiss for sure is not going to be granted. I have to still read the portion about whether the court will exclude evidence that they can no longer disprove. I have to read that and read the case law. I haven't done that, so I can't opine on that. Motion to use juror questionnaire, that probably will be granted. I haven't read it yet, but I think they use a questionnaire. Oh, I think that they requested one last time, and the judge had denied it. I'm not sure. I have to read it. Motion to suppress evidence derived from wiretap interview. I haven't read that one yet, so I can only comment on the ones I read, and so far I already commented on those. So, Dr. Cancella, is that a question? Thanks for saying I'm charming. All right. I think the bigger one sits a lot more, Judy. I think each bench sits about 7 people, and I think there's 10 on each side. So I think it fits. It would easily fit more than 100 people in there. That's my estimate. Drive safely. Question, James, your prediction when will be arrested? Would that be Wendy? I don't like to do that. I mean, I already gave my advice, my thoughts about that. Probably all four should have been arrested, but don't know. Which of the items do you think the defense will be successful in excluding? Hey, Skeeter. I didn't go into that part of the motion about excluding stuff, so I can't talk about that yet. I'll have to read it before I give any opinions. Miranda says that refuse to watch ads. Well, I think that the best way to support the channel, especially if you hate to watch ads, is to then buy the YouTube Premium. And that way we all get a little piece for the time that people actually spent on our channel. So that's what I would say. If you don't like to watch commercials, but you want to support the channel and you want to support YouTube for providing you channels that you love, then you just buy the YouTube Premium. Alternatively, you can also support by becoming members or doing the Patreon thing and all that. I still get a penny because I watch 2S. Yes, I know. I'm talking more, Judy. I'm talking more about it in the long run, right? So if all the people on YouTube watch ads that they don't give a damn about for half an hour. Let's say they just leave the ad running for half an hour. They don't give a damn about this weight loss thing, but they're just watching it so that the channel will get 2 cents. That means that the value that the advertisers get out of investing into marketing on YouTube is diminished because their goal is to sell a product, right? So if you have 99% of people that watch the ads because they want to support the channel, but they have no interest whatsoever in buying the product, then they're not getting a return on their investment, and then they might decide, well, we're not going to spend money on YouTube. Let's put the money somewhere else, and that's what I'm talking. All right. Okay, thank you, Shiraz. I mean, look, the audio is going to depend a lot on who's going to be running the media pool camera. And I think if Core TV is there, hopefully it will be good sound. I think you shouldn't confuse the sound from the professional cameras and the professional highly financed companies versus the sound when I'm recording or when I purchase the recording from the court system. That sound is pretty horrible. So thank you, Helen. I agree. All right. Why do you think state is transporting Charlie for trial? Well, that's very simple. They're transporting him here because he's a potential witness. So anybody who's a potential witness and is in prison should be transported here, meaning that there's always a potential that he might decide to cooperate. So if he decides to cooperate, he's here and hence not in another state and would not cause any delay of the trial or pausing the trial because now suddenly Charles Adelson wants to testify. It's not because they want to have a mother-son get together, but because of that, because there's always the potential that he will become a witness for the state. And it could be, could be also that the defense requested that Charles be moved here because he may testify in favor of his mom. Who knows? And the state might have done that as a favor. Okay, sure, we'll bring him down. But I think that they would always do that with anybody who might become a state witness and testify. Kathy Frank, question: would you be available to go live after the pre-trial on September the 12th and give us your commentary? Pre-planned live would be great. We do value your insights. I'm not sure. You have to look. I would have to look at my calendar, and I am more of a impulsive live when I can, given there's so many other obligations I have in my life. So I will try. I know that lives that are pre-scheduled and you guys can look forward to are usually performing a lot better than when I just show up. I understand that. On the, I actually did the most thorough review of the Donna Adelson calendar than anybody that I know. I mean, I haven't watched anybody else, but I ordered those records. I paid for them, and I did a very thorough analysis of all of them. So there are several videos about them here on my channel, so go check them out. In fact, I actually created a document that I have for myself about it. How would you get Catherine to cough up some truth? She knows it all. Right, that's the $1 million question. I know how I would do it if I were in charge. I would get Sigfredo Garcia and Catherine McManua in the same room. Sigfredo to give her the green light to tell the truth. If I could convince Sigfredo to, even if he doesn't want to cooperate, but to give his ex, the mother of his children, of their children, the green light to just go ahead and tell the truth without having any concerns for him, then she might give the full spill. Because we all feel, I think, that she was still not 100% forthcoming. I got it, Shiraz, no worries. And that was a courtroom camera from the court system, so of course the sound is really bad. It would be different, of course, if Court TV were filming my trial. Will Sigfredo ever be called to testify against Donna? Sigfredo will only be called to testify by the prosecution if he's willing to cooperate. And so far, he has shown that he has zero willingness to become a state witness. So that seems very unlikely. Furthermore, Sigfredo Garcia would not likely be able to give any evidence directly against Donna because everything that he knew was coming from Catherine McManua. He had no direct contact with anyone, so it would be unlikely that he would be called unless it would be to corroborate some of what Catherine McManua will say. Mm-hmm. Good questions, people. Defense lists Donna's 2014 planner. What are the chances they don't also have 2016 and other years? Huh? Are you serious? There is a 2014 planner? I need to request it immediately. Where is that listed? You're not joking, I hope. I'm looking at the state's defendant's reciprocal discovery. I hadn't reviewed it yet. Let's see. Donna Adelson 2014 appointment book. Huh. I'm going to order that now. Thanks. Sorry, guys. Interruption. I need to work. I need some work. I'll be right back. I'll be doing work for this case. Take a break. Well, there's definitely a lot to talk about in this case, and definitely I should have done a video already about this. Defendant's reciprocal discovery. All the people that they list in all the documents. It's only 2 pages, but I haven't thoroughly reviewed it and thought about it, so I'm not going to discuss it in detail here. But definitely that's something that I need to look into and maybe do another live about that. Unfortunately, I do have Crazy busy work schedule. So I'll do what I can, guys. Okay, I do what I can. Um, all right. Any other questions, guys? Thanks, kiddo girl. All right. So I don't have any stickers, but I do have T-shirts that are in the works with T Public. So we will finally have some T-shirts, including I think including that T-shirt about the stuff that something that looks similar to what Wendy Adelson was wearing in the interrogation room. Finally, gonna have my interrogation room fashion line. Thank you so much, Rabbit. That's awesome. I really appreciate it. Why am I not being able to click on it? What's going on here? Let me see. I go to start. There we go. Thanks so much, Rabbit. Early contribution for the 2014 plan. Yes, I just sent the request. So hopefully it's already 4:20 p.m. So most state workers are already enjoying the beautiful sun outside. But who knows? Maybe they're still there. Maybe I get a copy today. I doubt it. I doubt it. I wonder if I should ask the Rajmon whether he would send it. He's never sent me anything. So I don't know if I should waste time with that. So. Mm-hmm. All right. One second. Let me do a little work, and we'll keep talking. Put up your questions, people. I'll join you back in a second. Gonna take care of some work. Mm-hmm. Oh, Ladybug just told me that she uploaded a condensed version of the video I did last night about the courtroom size on Justice Network. So awesome. Maybe she can premiere it tonight. I'll tell her. Okay. All right. Got a little bit of work to do, so I'm gonna have to shut this down. All right, guys. Sorry that I was off for a second. Patricia Burns' question: How would you get? Okay, I already did answer that one. Was secret on witness list also? You mean the defense? Secret would always be on the list of. I don't think we have a copy of the witness list yet. This is just a list of people that may have knowledge, and Sigfredo Garcia is listed. Oh, actually, they do say as people who may be called as witnesses at trial, and they do list Sigfredo Garcia. Again, anybody who may have potential information, I guess Sigfredo would be called to say, hey, you don't know how to hire you, do you? Or, hey, you extorted us, right? Um, yes, Skeeter, I would love to do speedy trial. We'll see. Would you host other Justice for Markel creators? and come live to give your opinions. Judy will be appearing on my channel. She may be doing commentary about the trial. I have limited time, and by limited time, I usually spend it on my channel. So I don't go too much on other people's channels. I actually refused an interview with Court TV this week because last week I was on vacation. I'm gonna be more whenever I do something, it will be here usually. I believe that the state filed a notice of serving the witness list and didn't file it, so they probably just sent the witness list to the defense. Don't know why they didn't file that. Cool. Thanks, Miranda. All right, guys, I need to go. I'm not sure that I can give an explanation about that because I don't know how it works. But I can tell you that all of my videos have in the description a link about how you can become a member, and then they have a link about Patreon or PayPal, so you can, support that way. Hey, Brianna, nice to see you. That may be true. Okay, guys, I need to get going. Let me see if there's a final question I'll answer. Which lawyer are you bullying? Are you bullying LA? What is this, Judy? Sorry, this lawyer is a creep. I just ignore people like that, so don't worry about it, Judy. All right, guys. Okay, that's it. I'm done. Thanks for watching, everybody. Until next time. Oh, suggestion for a T-shirt. Lady Elaine Fairchild puppet from Mr. Rogers' Neighborhood wearing a Mr. X All right, guys. Have a good one. Again, thanks, Shiraz, for becoming a member. And thanks, Rabbit, for your contribution. Much appreciated. It will go towards the fund for the calendar. I did just receive an email, and it says, oh, I have to ask about that on Monday. Sorry. So, no worries. I am not going to get it today. That sucks. All right. I guess I'll find out on Monday. Thanks, guys. Have a good one. Until next time, Mentor Lawyer, have a wonderful weekend. I'll be out of town next week. So, don't know if I'm going to be doing any lives because of that, but I'll have my laptop. Maybe I'll take a camera along. We'll see. Bye.